reasons not to harm your loved ones in quarantine. It's 41. It is May 20th, I believe. It's been a really long day. 2020. As you know, most of you saw, we were delayed in going live today because the justice system just wasn't moving as quickly today as I had hoped. We were able to settle a case after working with the judge and making efforts and being in a hearing for almost 7 hours. So I'm a little sleepy right now, but we can do it. Today, just a couple of things that are interesting that are happening. Some of the colleges and some of the school districts have announced their plans for fall. West Bloomfield has talked about classes online. The University of Michigan has talked about having students on campus and doing some of the classes virtually. Well, some of the classes will be live. MSU has said that they will have fall online. Western has said they'll have classes online, and I think I misspoke earlier. The West Bloomfield School District is going to have, it sounds like they have several plans, and they officially hasn't been adopted, but it's interesting. One of them has half the students there at a time to ensure social distancing, and it's very creative. So if you're interested, those plans are on both the clickondetroit.com website as well as on the WXYZ. Is not on the West Bloomfield School District website, which I was surprised about that. The other thing that is kind of crazy, and this just, politics. I've talked about over and over again over the past several weeks how we are in a situation right now where we can teach our children. This is history in the making. Donald Trump, president, has threatened to withhold funding from the state of Michigan in response to the announcement yesterday that voters in Michigan will be allowed to vote absentee both in the primary in August as well as the general election in November, and that ballot will be automatically sent to every registered voter in Michigan. And he has threatened to withhold funding because of that declaration to keep citizens safe. The other things to keep in mind, unfortunately, we did pass the 5,000 mark for deaths from COVID-19. There's 5,017 deaths, up 102, which if you were today, we only went up 24. It's not really as much of a panic as it sounds like. But they're also reviewing death certificates to see if there were cases where the person actually did their cause of death was COVID-19, but it wasn't documented that way initially, or if it wasn't reported to be part of the statistics. So it's definitely not a good day for the death number, but it just needs to be kept in context. There's 52,350 cases in Michigan. That's up 435. And again, that number is bigger than what we had seen in the last couple of days. And we've talked about this. It has to do with the amount of testing that's available, the amount of time they can turn around the results. It doesn't necessarily mean that 435 people got sick yesterday. It means that the people who were tested in the last couple of days, their results finally came in. So it's bad. It's just, I like to keep things in perspective. And so the thing that I wanted to talk to you about today is about jury duty. And that is one of the things that, it's kind of, the way that people think jury duty will be, it's like they would rather eat mud and worms. And they think it's just going to be this horrible, horrible experience. And they do everything they can to get out of it. And then after they actually do it, I've never, ever had a juror tell me that it was a bad experience. Sometimes it was just really inconvenient, or it just was not really feasible for them to be there for as long as they were. But as far as the process, the respect for the legal system, the awakening of really the Constitution coming to life, and it being, this is your civic duty as as a person who is a citizen of the United States, is to have the ability, if you are accused, for the evidence to be evaluated by a jury of your peers. Jury of your peers is always a debate. How can it be a jury of my peers if I'm in an inner city, low African American, and my jury is a bunch of wealthy suburban white people. We try to have those disparities taken care of, and that it doesn't really happen that way, but sometimes, depending on demographics, it can't be helped. And so the ideal pool of jurors, and I'll explain what that is in a minute, is a cross-section of the community. It's not necessarily people who are just like you, who are the litigants or the defendant in the case. It is something that is absolutely necessary and critical for our justice system to work and to ensure justice. A jury is the ultimate fact finder, and it's the jury's responsibility to keep the checks and balances, to make sure, if it's a criminal case, that the prosecutor proves every element of the charges beyond a reasonable doubt. If it's a civil case, it's the jury's duty to make sure that the plaintiff proves their case by a preponderance of the evidence, which is 51%. It's a much lesser amount of evidence than is required in a criminal case. And the reason is because in a criminal case, you risk losing your freedom, your liberty. You could go to prison. Where in a civil case, they're talking about money. So, you hear all kinds of excuses, as I said, why people don't want to do jury duty. But I would love to be on a jury. I'm never going to have that chance. But it's a very interesting process. And the process starts by, obviously, you get your to come, and you have to go. And if you can't go for some reason, then you have to contact the jury clerk immediately and tell them that you can't come on that day and what the reason is. And they're going to, okay, then we'll put you back in the pool and we'll send you a notice to come in a couple months. And people don't really like that answer, but that's what happens. And the only way to be completely excused, if you are a citizen of the United States, is to, if you've been convicted of a felony in the past, disqualified. And if you are over 70 and you call and you don't want to serve, it's optional, not have to serve if you are over 70 years old. So that is, so then the jury clerk would that's one way that your jury service can be moved or excused. What happens most of the time is that people come on their day when they're supposed to, and depending on the kind of case, the severity of the case, that is the amount of people that would be summoned. In a criminal case that is a misdemeanor, for example, or if it was a juvenile case, you are only entitled to 6 jurors. So, and for criminal cases that are not, oh wait, no, that's not right, I'm sorry. So you're only entitled to 6 jurors. So they may call in, people for you to come up with your 6 that will be the deliberating jurors. Where in a felony case, where you have to impanel 12 jurors, or in a civil case where the amount at issue is over $20,000, they're going to bring in probably 60, 80 jurors in the pool. If you have a case, like a child sexual assault case or a child abuse case, those types of crimes, they're going to bring in even more people in the pool, because people who have had those experiences and say that they cannot be open-minded, whether it's with themselves or with their family members, are going to be disqualified and excused pretty immediately. So they have to bring in more people to accommodate that. So in the jury selection process, which is called voir dire, which means to tell truth or to speak truth, what happens is there will be questions that the judge, it's usually the judge, asks to the whole pool, to everyone sitting in the or in the courtroom area, and then at the end of those general questions, which judges do that differently. Sometimes they'll ask if they'll ask the questions, and they'll ask people to just raise their hand there and then. Some of them will ask all the questions, and then they'll randomly pick the number of jurors that are going to be in the box that are the proposed jury. And the first question to those specific people is, would you have answered yes to any of the questions I asked earlier? That is personal preference by the court that you're in. So some of those questions that are asked, right up front are, they'll give the approximation of how long the trial will take. So let's say that they say it's going to be a 3-day trial, or it's going to be a week-long trial. And they'll say, does anyone have, a hardship that they wouldn't be able to complete their jury service for the anticipated amount of time of the trial? And people, some people may say that they have a medical condition that allows, that precludes them from sitting. Some people may have, their daughter's wedding, and they have to do the rehearsal and all of that. A lot of people will say they don't have childcare. A lot of people will say that they're self-employed, and that they literally have to close their business in order to perform their jury service. And so, everyone kind of gives their reasons, and then it can be decided if it's appropriate for them to be excused for cause. And I'll go into the 2 different ways you can get excused in a minute. But the other questions that might be asked is, the witness list will be read, and a big group of people will be asked, do you know any of the proposed witnesses? Do you know the attorneys? Do you know the clients? Do you know the court staff? Do you know? And then people would raise their hand and say that they do, or if they do, that they do, and what the relationship is. Another general question that can be asked at the beginning, and usually is if anyone has any law enforcement in their family or relations to law enforcement. That is a possible question in those initial questions. They'll ask if anybody has any disability. They're pretty general, those initial questions. And then after that is concluded, then the clerk will pick, depending on what kind of case it is, they'll pick people to go in the box to have a more pointed interview, for lack of a better word, to determine if they can be unbiased, impartial. Can they look at the evidence, hold the prosecutor or the plaintiff to their burden? Can they be fair? And there's various, ways that those questions are asked, and some of them are very case specific. And so if you have a criminal case where 12 jurors are going to deliberate, then the judge would 14. So there's always two alternates. Well, actually, there's always one alternate, and in some cases, there's two alternates. So if something happens throughout the trial, you can still have the 12 people to deliberate. If nothing happens during the trial, then before they go in to deliberate, the clerk, one name if there was 13, or two names if there was 14, and they would, those two would be excused, and they would not actually get to deliberate. The next thing that happens is the judge would ask more specific questions of the jurors, and they would be instructed, and they would both parties, the individual attorneys, opportunity to ask questions. And so there's a lot of different theories about voir dire and about asking questions. And for me, it's a time to build a relationship. It's a time to see how what the people's thoughts are about things that are important to my case. So let's say that I have a case where I have a 5-year-old making an allegation. I would like to identify who my jurors are who believe children don't lie. I would like to identify who my jurors are that have experience or lack of experience with children of different ages. I would like to know if people believe that everyone who's been in a courtroom and has a trial must have done something. I'll ask them questions about, if you believe that something happened, but you're not sure what is, that I will explain that is doubt, and because it's your reasonable doubt. The questions that the prosecutor usually asks are more like CSI questions. You understand that just because someone's charged with a crime, there doesn't have to be DNA. There doesn't have to be lab results. There doesn't have to be fingerprints. There doesn't, and they want to make sure that they're not being held to the TV standards. They also ask a lot of questions about, the kinds of evidence that people expect to see. They may go in, similar things that the defense would, and, what their attitudes are about children. I always like to ask if people are involved in any charitable organizations and what they are. Certainly on in a drunk driving trial, you don't want a jury full of mad moms. So, there's just different things like that we want to explore. and get them up. They will be asked if they ever served as a juror before and on what kind of case. They'll be asked if they, if about credibility, and because someone wears a uniform or a badge, they hold them to a higher standard as more of a truth teller, and just different questions like it's imperative that they understand the burden of proof. And you don't usually do jury trials in, you know, the civil cases that I do. So, you know, usually they're in personal injury cases that you would have a trial, as opposed to a family law case. And so, in that vein, you know, I always want to make sure that they understand what beyond a reasonable doubt is and how much evidence that is. It's actually more evidence than someone can have their parental rights terminated. It's more evidence than someone can get, you know, $8 billion for a car accident. It's not absolute certainty, but it's damn close. And we need to make sure that jurors understand that. I also always want to make sure that they understand that there aren't two sides of the story in a trial. It's counterintuitive, and you don't get to hear both sides because the defense has no burden. We don't have to do anything. So you only hear one side of the story. Can you measure that without weighing in that their defense didn't put in any evidence? That is critical to make sure jurors understand. The other thing is that, you know, I always ask jurors, you know, does anyone feel that if you didn't commit a crime you're accused of, that you need to sit in this witness chair and say, I didn't do it? And some say yes. And we have to go through and explain that, but we don't have to. You know, the defense has no burden, and you can't hold that against him. And, you know, and we go through again, you know, can you look at the evidence? And that can't count if he never sits up there and says, I don't do it. And the judge will have already instructed this possible jury panel that the accused is presumed innocent, and that he is innocent until the prosecutor has proven beyond a reasonable doubt that every element of the crime has been committed. So he's cloaked with this innocence literally until after closing arguments, after the jury instructions, and then they take an oath and they go in to deliberate. It is at that minute when they're in that room, they're deliberating, that they have the power to take off the cloak or not by saying that the case has been proven beyond a reasonable doubt. So that is, you know, something that a lot of people don't realize. There's also, you know, this notion of the presumption of innocence that we must make sure our jurors understand, and that it is not the way we live our lives. I mean, everybody reads the newspaper, and this morning I read a young boy who was arrested for finding a gun and stealing this gun. And you know, you see his picture, and you know, it says, you know, on whatever his name is, arrest as the headline. And what's your reaction to that? You know, did you say, oh my goodness, I wonder what he's innocent of? Well, as a juror, that's what you have to say. That's what you have to have, is that nothing has happened. No crime has been committed. There is no victim until the finder of fact, the jury, decides that something has happened because it's been proven. So a lot of what goes on in voir dire is educating the potential jurors, coupled with the jurors engaging in conversation. And, that's my goal, is to find out who they are, how they think. And, if there's someone that I think is open-minded enough that they can say not guilty. A lot of people, can't get that somebody's been arrested and we're in the courtroom and, they're guilty. Some people feel that their own personal experiences, although they say they can decide and be fair, maybe they are really pissed about what happened in their case or a loved one's case, and they're going to punish, my client or punish the government because of the injustices in prior cases. So are asked a lot of questions. They're asked a lot of personal questions, and it's not prying. It's just really to let us know if you are the best and most appropriate person to be on our jury. Some people are great jurors for drug cases, but they're horrible jurors for a child abuse case. They may be great jurors for a murder case, but they can't sit on a sexual assault case. So it's not meant to, be embarrassing, this voir dire process. It's not meant to keep people out. It's meant to reveal if they can be fair and impartial, and can they actually stick to their opinion. Can you hold out if the other 11 people think this, but you think this? Are you an independent thinker? Maintain that opinion and that judgment, and your conclusion based on the evidence. And it's a very interesting process, and that is what I think people that I've talked to after they've served on a jury, that's the part that surprises them the most, is that they actually did have these beliefs, and the kind of the mental Olympics that they went during deliberations, and they looked at all the evidence, and they a lot of them report that they okay, this person's not guilty, but what about this? And then they'd be like, well, that wasn't really proven, so he's still not guilty. Or the other way, like, they're supposed to start at not guilty, but they definitely talk about it both ways, and about each individual element or ingredient of the case that has to be proven. There's always about stereotypes and reaction to the charges. And when you saw my client sitting here, what was the first thing that popped in your mind? If someone's honest and says, oh my God, he looks like a total creepy stalker, then obviously I don't want them. So there's, things like that are really important. It's, I spend a lot of time listening to the answers to asking questions. And I just hope people are truthful with me, because I do want to have the best jurors I can have. And, if people aren't open and honest about what makes them think and how they react to different situations, that is going to be detrimental to the process and to my client receiving a fair trial. Voir dire is, in some courtrooms, it can be limited by time. The judge may say, you get 10 minutes, you get 10 minutes, and that's it. It may be limited to case-specific questions and facts, or it may be you can ask anything you want. In some cases, we use juror questionnaires so that we have a lot of information before we start asking questions that's case specific, and that's helpful so that we can immediately address the people who are victims of crime and talk to them individually I always ask for that to take place in private, and immediately excuse those people if it is a situation where they need to be excused. There are two ways that you can get off a jury once you report and are chosen to be part of the panel. And that is, you can be excused for cause, which means that there is something that has come out during voir dire that shows that you can't be fair and impartial, that you can't hold the prosecutor to burden or to the plaintiff to their burden, or there is something going on in a person's life that is just so extreme, there's no way that they could give their full attention to the trial. Excuse me. The other way that people can be excused is what's called a peremptory challenge. A peremptory challenge is basically when someone is excused and they don't know why. When we're looking at jury panels and our possible jury panels, we are looking at people both individually and how they come together as a group. For example, if an issue in the case is, an overreaction by a mom, then a bad interview of the child, then I would want one person on the jury at least who really understood reacting to a child's report of any sort of danger. It doesn't have to be abuse. It could be falling out of a tree. It could be, anything where their child was not okay. And what do they do? And how do they react? And are they so hyper vigilant that they're looking for it all the time? Or is this just, a fluke and they can't believe it because they never conceived of it? So I want to have someone on the jury who's had a similar experience to that, so they can take that piece of evidence into the jury room and be like, yeah, my kid fell out of the tree and I did it, or whatever it is, to, kind of judge the behavior or the statements of the witnesses. And then we would want someone who does interviews. Maybe it's an HR person, maybe it's a teacher who has to, bring 4 kids in the hallway and say, okay, who did this? Maybe it's a parent who, that's how they solve conflicts between their children. So we want someone who has had to make a decision on what really happened based on talking to people. So that's the piece that they may bring into the jury room. So it's the dynamics between the different jurors, as well as the individual jurors. Another thing that we always look at in addition to this composition is, depending on the case, some cases it's better to have concrete thinkers who put square pegs in square holes. And in some cases, it's better to have more creative thinkers who figure out how to put the square peg in the round. You just go get a bigger round hole. And so, that's very case specific. And that's something that, individual case basis, you kind of figure out, who you need. If you have a case where there's no medical evidence, no injuries, yet the allegations through common sense, then you might want a medical person on your jury who's going to say, yeah, like if this person was beaten every single day with a baseball bat, for 5 hours a day, yeah, when he went to school, the teacher would have noticed. You need that kind of piece of reality and common sense. whatever that may look like. So that's just something to think about. And a lot of times you want to know if people have children, if they're adults or adult children or minor children, if they're grandparents, and you want to know a lot, where have they traveled to. If you have a sexual assault allegation that's kind of they met in a bar, they were really drunk, or they were at a frat party and they were really drunk and had sex, and she woke up in the morning and said it was rape. You want to make sure that you have neighbors who believe that can happen, and that can be it could be real, or it may be made up to save face. What if her boyfriend was like, where the hell were you last night? And the easiest way for her to get out of trouble with her boyfriend was just to say, oh my God, I was raped. Or a lot of times we see children who are in trouble, about to get in trouble, and they say, I can't believe you're doing this to me. I've been sexually abused by your husband, Mom, who's not their dad. And, we see a lot of different interactions between children and adults, and trial, where we had a circumstance where my client and his girlfriend had a history of going out and dating, months or years, and then they'd break up, and then they'd run into each other at the bar, and then they would get drunk and they'd go home and they'd be back together for a few months. And this went on for years, and that was the pattern. And it was the same bar, and they were very well known. It was in a small town in northwestern Michigan, and we actually had the bartender testify at the trial that there's no that she wouldn't consent to this. They were all over each other at the bar. It was like every other time that they've gone through this pattern. And we did in that case, actually, the prosecutor put on their case. We had all our witnesses there. We had an expert there. And we chose not to put on a case at all. We didn't call any witnesses. Literally, we came back from lunch. The judge said, call your first witness. And we said, Your Honor, we rest. We are not going to call any witnesses. And it was kind of like a big to the jury, the judge, to the deputy, to everyone in the courtroom. I mean, it was a huge risk to take. We were really relying on how smart was, but we were really confident in our jury. We actually had a police officer's wife on that jury, which was really interesting. So they're all individual. They're all on a case-by-case basis. And the decision to have a jury trial or not is certainly something that we have to talk about in every case, because once a client waives the right to a jury, you can't get it back. So it is something that we have to talk about at length, and what the pros and cons are. Sometimes in a child protection proceeding, we ask for a jury because we can't get it back, but we don't really intend to have a jury, because in a child protection proceeding, a termination of parental rights proceeding, for example, the jury only decides one of three parts of the case. And they're told that they have a very limited role, and they're only to decide whether or not the court has jurisdiction, which means in English whether or not this is a child who needs protected. And so they don't have the ultimate decision-making power on where this child lives. They don't have the ultimate decision-making power on if the parents' rights are going to be terminated. They're going to be able to work on a reunification plan. And so part of the instructions, they understand this limited role that they have. And my 26 years of experience in most of those circumstances, the jurors have reported, yeah, we took jurisdiction because we didn't want to be wrong. And, if the judge is going to figure it out afterwards, then let the judge figure it out. We don't want to morally go home and be like, oh my God, we sent a kid home that, could be in danger. In any kind of assaultive crime, that's another part of being an attorney in a jury trial, is that we do have this extra piece where we have to make our jurors comfortable with their decision. We have to give them, all the reasons that the plaintiff or the prosecutor has not met their burden. We have to give them, much more undisputed reasons to say, okay, yeah, the plaintiff is wrong, the prosecutor is wrong, or they didn't get to their burden of proof. And we do that through different techniques, but one that is very effective that we use all the time, we use it literally from voir dire through opening, through our cross-examination, through closing, is, we're going to tell a story, and this is what the story is, and this is the story that makes sense. I personally don't take cases to trial that I don't think I can win. And if it's a case that, you can't win, then you probably need to be looking at other options other than the hands of a jury. So that's a conversation for another day. But, just some other things that we, always ask jurors, we always ask them, if they've ever made a mistake and then found out that, that it was based on jumping to a conclusion as opposed to looking at all the facts, and to tell us about that. We ask if they've ever been suspected of doing something that they didn't do. We've asked them if they have ever been involved or know anyone that's been falsely accused. And just different things like that. We want open-minded people who who can, as I said, who can hold out on their own beliefs. People do have really strong beliefs, and beliefs are, show a bias, and we have to kind of get through those and see how much of that bias is going to be a factor in them looking at the evidence, or if it's not going to be a factor. I personally think that it's really, really hard for jurors to be honest and say, yeah, it does affect me. It affects the way I look at the world. I think that everyone in their heart of hearts wants to believe they can be fair and impartial. And it's doing a disservice if you can't, because of some articulated reason, to say that you can. There's a question that a lot of attorneys ask. I don't ask this question. I think there's better ways to get this information. But it's, if you were the one who was sitting in the chair as the accused, how would you feel about you on the jury? And I don't love the question, because I think that most people will say, oh, I'd be happy with me on the jury. I think there's better ways to uncover the preconceived notions and bias come into the courtroom with. There's other questions that you can ask. If you, again, you can go about it that there aren't two sides to the story, and how do they feel about that? Or, as soon as you heard the charges, what popped in your head? I mean, what easier way is there to tell if someone's biased than by their reactions as opposed to answers? So that is, that's basically, what it is. And then the trial will begin, and throughout the trial, they're not allowed to talk about the case. They're not allowed to talk to the parties. They're not allowed to talk to the attorneys. They're not allowed to talk to the jury. And they're not allowed to talk about the case amongst themselves. So there's always an instruction at the first break after they're impaneled, where they're told that, nobody's being rude. They're just, they're not allowed to talk to them. And it's very awkward to be in an elevator with jurors and that's your, they know you're the lawyer, but you have these blinders on and you're like, please don't talk to me, please don't talk to me. Because if they do, then, I would have to report that to the court that I was in the elevator and we had this hey, what'd you have for breakfast kind of conversation. And it just opens a whole can of worms. But also in the restroom, it would just be normal when you recognize someone to say hello, but we're not allowed. And that's why, because you don't want anyone talking about the case or being influenced in any way until, as I talked about earlier, they're uncloaked. They're allowed to go in the jury and evaluate if the defendant should be continue to be cloaked with innocence or if he should be uncloaked and found guilty. If they can't do a decision, that's a deadlock jury. And different courtrooms, different cases, judges hate mistrials. I think everybody hates mistrials, but there are certain cases where a jury is deadlocked and can't decide, and there's no other option. Judges have different beliefs as to how long they should have to deliberate before they'll call it a deadlock. There are other circumstances other than deadlocked when a jury may not get to deliberate. And that would be a circumstance where there was something so prejudicial that occurred actually during the trial that the jury never got the case to deliberate. A mistrial was declared in the middle of trial. Another thing that could happen that would take the deliberation process away from the jury, the prosecutor is done with their case. The defense would make a motion for a directed verdict. And basically we're asking the court to acquit our client based on lack of evidence on each element of each crime that's charged. And so at that point, the judge can, dismiss counts or dismiss or say that or deny it, and then the case would proceed to the defense putting on their case and then the jury deliberating. The standard of proof for the direct verdict is the judge has to look at all the evidence in the light most favorable to the prosecutor because they have the burden of proof. And so we don't win very often there, but there's been a few along the way. And so after the proofs are done, then as I mentioned earlier, there'll be closing arguments. And that the prosecutor goes first, then the attorney, and the prosecutor actually goes again. It's their burden of proof, so they get to go first and last. And then the jury would be instructed and they would go in the jury room and begin to deliberate. And they can, they'll have all the exhibits in there. They'll have a copy of the instructions. They'll have a verdict form. Sometimes they ask to have testimony read back. Some judges will do it. Some judges won't do it. But basically they're supposed to rely on their collective memory. A few years ago, there was a new court rule in Michigan that allows jurors to take notes during the trial and also allows us to ask questions during the trial. For the most part, I feel like it has made trials longer, but some of the questions I think have been very valuable and very helpful to the fact-finding process. Some of the questions are completely not allowed and are not ever asked to the witnesses that they're posed to. I think that during deliberations, in talking to jurors on ask for testimony to be read back. That's a direct result of them having conflicting information in their notes. And as I said, most judges don't want to have it played back or read back because they have to play back the whole thing, not the one little part that the jurors are looking for. And so, but again, that's case by case, judge by judge. And so that's, what happens with that. If they have questions during deliberations, they can ask them and they may not be answered, depending on if they're allowable questions or not. There's a lot of discretion given to jurors. If they want to stay till midnight, the judge will usually say, okay. If they want to come back the next day, the judge will usually say, okay. It just really depends on when it is during the week, when it is during the year, all that stuff. I always found it kind of amusing that if you have a jury out, a lot of verdicts come back Friday at 4:30. But I've had a lot that didn't come back then as well, but that's kind of a joke within the legal field. After you're done with your jury service and if it's either a verdict has been rendered or not, but if the case is over, then the judge usually comes and talks to the jurors, have an opportunity, if they want to speak to the attorneys, and they can ask questions about they always want to know about the inadmissible evidence and what facts they didn't know. And I'm always interested in asking, like, if you had known this, would it have made a difference? And I always ask, what do you think was the strongest part of the defense case? What do you think that was the weakest? What do you think was a waste of time? I really want to gauge from these people as to how to do it better next time. And that's why we do mock juries, and we do focus groups with a lot of our cases, so that we do give them the answers to the questions. We know from research that if you don't give them the answers to the questions, they make it up. They put in if you don't tell them that it's a 2-story, red house in the middle of a bunch of farms, they're going to assume, it's a ranch in the middle of the neighborhood. So, there's details that we learn from doing these groups that we always want to give our juries, because we know they fill them in. And so, as I said, after people serve on a jury, I've never had a juror say that they didn't learn something about themselves and the bad experience for what it was. Most people are just like, wow, like, I did my duty as a citizen. I did my part in justice, and it's a great experience. So as much as people are always wanting to get out of jury duty, I encourage you to do it. It's really neat. The process is as constitutional as you can get. Rights are alive and well right there. And your right to an attorney, your right to an effective attorney, your right to remain silent, your right to confrontation of the evidence against you. It's cool. And so with that, I will say, don't begrudge the summons as it comes. Embrace it. And remind you of the friends. Before I even get there, we are going to do a Zoom mock jury next week. I'm not sure what date yet, but if it's something that you're interested in being part of, I would love to invite you to join that Zoom meeting. So if you want to just, either messenger me or send me an email or put a note on the Facebook page that you want in, I'll make sure that you are invited. And then if it fits in your schedule, we would definitely love to have you. how they work is basically we give you, little bites of evidence at a time, and we figure out what impact that evidence would have on, on the jury. And if you heard this, does it change your mind? What else do you want to hear? And it just helps us really develop the case. And it's just a really great process, and I encourage you all to participate. So 5 reasons. Number 1, protective services workers are essential. Number 2, the police are essential. Number 3, our jails and prisons are the hotbed of COVID-19. There is an appropriate disinfecting. There is an ability for social distancing. You have to eat really close quarters. You know the drill. Number 4, parents can get in trouble for kids being kids. And number 5, finally, very few people, if anyone, look good in horizontal stripes. So with that, I thank you for tuning in this late edition, and I hope that you all have a really, really wonderful day, and I will see you tomorrow. Bye.